May it please the court. I'm Andrew Rayner. I'm the litigation director of the Public Health Advocacy Institute in Boston, which is a nonprofit organization committed to litigation affecting public health. I'm here today on behalf of the family of Thomas Babaletos to ask you to reverse a judgment that was infected by unnecessary and unfair time limits. The time limits were unfair in at least 3 respects. First of all, that they were set without consideration of either party's submission as to how much time they needed to try their case. Secondly, the limits did not, as required by the Chandler case, allow the plaintiff to present her entire case. And third, the division of time between the plaintiff and the defendants did not take account of the burdens of proof faced by those parties. Taking these one at a time.
Counsel, how many days of trial did you get?
We had a combination of half days and whole days. It was measured only ever in minutes, Your Honor.
Was it 3.5 weeks?
It was 3.5 weeks only if one counts days that the court did not sit. It was not 3.5 weeks.
So you don't, how much time, how many days was the trial held? Was it 27, 28? What was it?
Your Honor,
You're saying you didn't have enough time, right? You're complaining about the time limits. I'm surprised you don't know how much time you actually had.
well, we had 28 hours, Your Honor, and it was meted out in days and counted by the minute.
Okay, and how much time, if any, did you have left over of the 28 hours that you were allotted?
Had 20 minutes, and it was only because we needed to call, the trial judge told us we could only call a particular witness as a rebuttal witness. So we had to save time for a medical causation rebuttal witness who was called last. And the fact that we didn't use those 20 minutes bears no relationship to the testimony that we asked the judge to be able to present, which would have required at least 3 additional trial days.
What did you want to present that you didn't get a chance to present?
So I've outlined on, excuse me, Your Honor, on pages 33 to 35 of our opening brief, we detailed the witnesses that we did not get to present. I'll give you 2 examples. The first was a videotape deposition of a representative of defendant R.J. Reynolds Tobacco Company, who testifies in that deposition, among other things, that the company expected people to rely on the statements that they made that were misrepresentations concerning the dangers of cigarettes.
And so dealing with that one piece of evidence that you were not able to put in, did you ask the trial judge for time to put that specific evidence in?
Yes.
Okay, and that request was denied?
And let me address, if I may, let me address the timing of all this.
But before you do the timing, can you answer my question? Where in the record did you request to play that particular piece of evidence? And where in the record was it denied?
You will find, Your Honor, in the transcript of October 1st on page, in the third record, in the third volume of our trial record at pages 37 to 43. And again, in the hearing on October 8th, you will find it in that same volume at pages 237 to 248, where we laid out exactly what we were not going to have time for. It was also laid out in our pretrial memorandum, which Your Honors will find in volume 1 of the record.
Seems
Go
like,
ahead. Sorry, go ahead.
Please.
Justice Lloyd, please go ahead.
it seems like your reply brief and appellee brief have significant differences as to what happened. And in particular, whether or not and how many times you actually asked for additional time.
So I've had the pleasure of opposing Mr. Chesson many times. And I have the highest regard for him, but he did not accurately represent, Your Honor, the situation. The trial judge was not flexible. We asked at the first 3 hearings, there was a hearing on October 1st, which I've mentioned, where the judge announced, before he had heard anything from either of us about how much time we needed, he decided that day that we were going to have 1,575 minutes and that the trial was going to end on November 9th.
That was in response to a motion filed by the defendant.
It was a response to a motion filed by the defendant, which did not suggest any particular time.
This wasn't sua sponte by the judge. He was responding to a motion, right?
Well, what was sua sponte, Your Honor, was Your Honor is correct.
Okay.
But it was, what was sua sponte, Your Honor, was the conversation that he had with another judge who had tried another case and and his understanding of how much time that other case had taken was mistaken. He says on the record, the other case, the parties each had 1,000 minutes. I'm giving you more time. That's not what happened. The parties had the same amount of time in that case that we had in our case, and we had 3 defendants and 5 causes of action, whereas the prior case, the Laramie case, had 1 defendant and 2 causes of action. So tobacco cases are not one size fit all. The defendants cite, for example, a bench trial case where they're comparing a trial of a 93A count before a judge and says that's an analogy for what we should be doing in a jury trial with 3 defendants and 5 causes of action. I actually went through and tried to count how many elements we'd have to prove.
You agree this is a matter of the judge's discretion. We have to find abuse of discretion, correct?
Yes, Your Honor.
And is it your position that had the judge complied with something that's similar to the ABA civil trial practice rules and gone through the analysis, he would have been fine?
Yes, Your Honor. He did not. He did, and the one other important part.
Because that would take out the arbitrariness of his, as you say, his ruling.
It was arbitrary. And Your Honor, the Chandler case talks about a party being able to present their entire case. If we go to a judge and say, as we did, in order to present this case.
Well, you've been a party to cases where the judge has said from the bench, move on, right?
Yes, Your Honor.
And that's perfectly fine.
Agreed. I mean, if we're to talk about, I mean, on a strictly theoretical level, I respectfully submit justice is never delivered by minutes on a chess clock. Justice is delivered by judges who allow the parties, who take input onto how much time they need. Doesn't necessarily, we've had since this trial 2 cases, which I cited in my reply brief, where the judges asked us, how much time do you need? I told them how much time I needed. They gave me not that much, but gave me enough time to make the case. And we had no trouble complying with time limits in either of those cases.
But the cases you cite where we find abuse of discretion are extreme cases.
I
The
agree.
Hawaii case, the appeals court case, where judges are cramming, multi-week trials into, 2 or 3 days. This would be the first time we've done something like this, right? Where you have a pretty long trial, almost a month-long trial.
Your Honor, may I just point out,
Go
the
ahead.
28 hours is 5 trial days. I've tried many of these cases. I've never,
All right, could remind me, was it 28 hours each or
Yes.
28?
so my trial
it's-
time was 5 trial days.
Right, so 2-week trial.
Yes, Your Honor.
But again, the cases you've got are extreme cases. We would be really changing the case law if we find this to be an abuse of discretion, wouldn't we?
Well, Your Honor, I think that the case could turn on the point I began with, that the judge made a decision before he had heard from me, a word from me about how long I needed.
Is that really the problem? Because what if the judge had, without hearing a word from you, said, you have a month? Would you still be complaining about time limits being arbitrary?
Well, I mean, while I certainly understand the point is that we didn't have enough time. We didn't get close to what we said we needed.
So it's some
and we-
combination of your lack of input and the actual time allotted. So it's not just the lack of input.
Yes, and the 2 elements, I'm respectfully asking the court to give guidance to the trial courts, no matter what else you do here, that says you've got to take input, you've got to take account of the burdens of proof. And again, I want to note that all of the other tobacco cases where time limits have been imposed, plaintiffs have been given more time because we literally, and I specifically asked the court to read the Trouble with Time Limits Law Review article, which includes empirical studies about other trials throughout the country. And it says unequivocally, it is the plaintiffs simply need more time. A defendant can win the case. They give the analogy of a builder. They say a builder can build the house, and if the party that wants to wreck the house, which is not a complete analogy, but if you assume that all the defendant has to do is disprove one element in order to win, there's no way the builder can keep up with the wrecker. The time cannot be evenly divided, and none of the other cases have done that.
Attorney Rayner, can we get to what the responsibility of the attorney who is objecting to the time limits, what's that responsibility? And what I'm going to ask you about is there a requirement for an offer of proof? Does the Mass Guide to Evidence 611A that allows the judge to control the mode and order of presentation of witness infuse enough discretion here? And if it doesn't, why not? Why not an offer of proof if the problem is that there's evidence that's being excluded that you want in?
So the most important part of this, and I wanted to say this earlier, the most important part of your question, Your Honor, is timing. And I'll tell you why. Because if you wait until the jury is impaneled and the jury has been told, you can expect you're going to be done by such and such a date. No one, none of the litigants, no judge wants to vary from that. So the time for input on this has to be before you start, before you tell the jury that magic number. So all of the points that were made about we didn't ask close to the end of the trial, we didn't ask, a responsible lawyer is not going to be placed in a position of going through 2 weeks of trial. In fact, we said that at the hearing on October 8th. We said to the judge, we can't be in the position where we're in the middle of a witness and you say, okay, that's it, we're done now. The time,
He didn't do that, right?
Right.
He didn't do that. He never did that.
of course not. And my point is, the time that this judgment needs to be made is exactly at those pretrial hearings. The parties, under all of the trial court rules, are required to give estimates of how much time they need and who their witnesses are going to be. And that's the moment when this decision should be made. And so the offer of proof, you never even get to that, because once the judge has impaneled the jury and said, this is when you're going to be done, nobody wants to be in the position then of saying,
Mr. Rayner, at that point, it's appropriate for the judge, correct me if I'm wrong, to take into account her experience with similar cases and perhaps colleagues' experience with similar cases to say whether or not the time limits proposed by the parties are reasonable or unreasonable.
yes. But the point I had tried to make, Your Honor, earlier about that is this isn't one size fits all for
I know, but
tobacco cases.
so if I have a case and it's a hand-to-hand drug sale, I kind of have in my mind how long a hand-to-hand drug sale should take place. I have in my mind how long a slip and fall in a supermarket should take place, correct?
Absolutely, Your Honor. But
I get your point about
but-
one size
but-
fit all
but
and
five
having input from the lawyers to say why this should deviate perhaps from what the judge's heartland is.
Well, and I mean, perhaps the easiest distinction in this case is this was a case where there was an actual dispute about medical causation. In many of the tobacco cases, medical causation isn't even disputed. In this case, there were 3 witnesses that were called on that subject alone. And that's was certainly not true in the Laramie case, nor frankly in almost any of the other cases that have been discussed.
So you had 28 hours and you didn't use 20 minutes. How much time would have been reasonable?
3 more trial days, another 15 hours. Your Honor.
15 hours. So the
Yes.
difference between 28 plus 15 and 28 is what you're saying is an abuse of discretion.
Absolutely. And I'm saying it precisely because there was specific evidence, which again, I've tried to outline, that we couldn't present. There was evidence that we have presented in other trials that, from my perspective, has made a difference.
So there were the 2 videos, and what was the last thing?
There was a very important expert witness, Dr. Prochaska,
The
who's,
addiction expert didn't overlap at all?
no, there is an overlap. What we had to do, Your Honor, is we had to use one of our other experts to cover topics that that expert would have covered. And we couldn't cover them all with the other expert.
But, because he's gonna stand up and say there's a lot of duplication, right? You've
Yes.
got 2 videos in your addiction expert where what you weren't allowed to do. But you get that testimony in through others, right? May not be as effective or comprehensive, but you do cover those topics with other witnesses, right?
In part, Your Honor, yes, in part. But I mean, to win a case like this, we need to persuade the jury, for example, that they were negligently marketing cigarettes to children. To have an expert who speaks precisely to how children are impacted by advertising is very important.
And I get that, because we've just written on that. But so the other witness who was allowed to testify, I take it they did talk about marketing children. I've not read this entire transcript.
That's true, Your Honor.
Did they talk about marketing to children?
did,
and
Your Honor.
How susceptible they are and how Joe Camel and that kind of stuff is? Are we going to find that when we read through this?
Yes, Your Honor. But my point
Is
is,
that what trial judges have to do, right? They have to decide how much duplication is going to be allowed, right?
Your Honor, had we had that conversation before the judge decided how much time he was going to give us, I would feel, I don't actually think we would have brought the appeal.
I think I need to ask you sort of an uncomfortable question, which is your suggestion that the judge is making these determinations based on his own personal schedule and whether or not that's really fair. And I want you to have a chance to answer the question, but he's has a conference coming up, a Superior Court conference coming up. There's the November 11th holiday. He's clearly working at night and in the morning to try and move things along. And then he provides some extra time when he recognizes November 11th. And one of the reasons you say this is an abuse of discretion, that's why I think I need to ask you the question, is because you contend that the schedule was driven by his personal schedule. And is that really, do you think that's true?
Your Honor, he said so at the hearing on October 1st. And I asked him about it again at the hearing on October 8th. I specifically said, I understand Your Honor needs to be gone to Memphis on November 17th. I mean, it was specifically discussed as part of the decision about, I mean, and he says, Your Honor, he says, I'm flexible about not my deadline date. He said explicitly that that was one thing that he would not vary from. And I mean, Judge Saroof worked extremely hard during the trial. I would not stand here and suggest for a minute that there was any shirking. I am absolutely not saying that. He worked really hard to get the trial done as we talked about. But I mean, is it good justice to be getting rulings on evidence in the middle of the night? Is that good for anyone? Is that a good quality of justice? I mean, to me, it's in the league with, should justice be delivered by the minute? It shouldn't be. It shouldn't be crammed in. And so I want to be completely clear. I'm not suggesting there was anything that Judge Saroof didn't work hard to make this done, but I am suggesting that the whole date was driven by what he told us on the first day and the fact that he wouldn't vary from it. The only variance, as Your Honor correctly points out, is he realized we weren't going to have Veterans Day, so he moved the closings to November 15th. That was the entire change he made from day one until the end of the trial.
Okay.
Thank you very much.
Thank you very much, Your Honors.
Attorney Chesson.
Good morning, and may it please the court. Scott Chesson from Shook Hardy for the Appellees.
How can you tell the plaintiff how much time they need to put on their case? I don't understand how you can argue that there was plenty of time.
Because we weren't making this decision in a vacuum. With all due respect to my friend on the other side, the judge did not walk in fresh and sua sponte say, here's how many minutes I'm going to give you out of the blue. This was briefed, where the defendants filed a motion, said, we want time limits on this case because otherwise they tend to run long. Here's a body of evidence of other cases very similar to this one involving the same claims, the same parties, many of the same witnesses. Here's how long they took. The plaintiff filed a 10-page response. It's on page 66 of volume 1 of the record on appeal, in which they said, we don't think there should be any time limits at all. Here are the witnesses we plan to call. The judge, after reading that, spoke with Judge Davis, who had just had a similar trial, which, contrary to what Mr. Rayner said, did not last the same amount of time as this one. It lasted 43 hours as opposed to 56 hours. And Judge Saroof walked in and he said, here's my inclination. After reading your papers, after examining what you say you're going to do, after talking with two colleagues, Judge Davis and Judge Wall, who have tried similar cases, my inclination is this doesn't need to be a month-long trial. I think about 1,500 minutes should cover what you need. Now let's talk about it. And then we talked about it. We had a hearing on the 1st, we had a hearing on the 8th. Mr. Rayner made all of these points to Judge Saroof. We made points in opposition. The judge made various adjustments to his initial inclination. And then, and I think this is key, and I apologize because I don't think this comes out clearly in the briefs, but I was, when you prepare for argument, you reread things. Page 37 of volume 3 on the record of an appeal, which is what Mr. Rayner just referenced, the judge said, I can't be flexible on the end date, but I'm building in a lot of half days to this. You want to turn a half day into a full day, just let me know, I'll be flexible. On page 42, he said, if there's ever a day where we're ending at 4 and you need to go till 4:30, let me know. And the point that we tried to make in the brief is that at no point during this trial, this 3.5-week trial, did the plaintiff ever stand up and say, Judge, there's a video we really need to play and we haven't had an opportunity to play it. Tomorrow's supposed to be a half day. Can you clear your afternoon calendar and we'll play that video then?
Is it your position the judge complied with the ABA standards?
I think the judge, if
I
the
mean,
ABA standards,
the
yes.
second ABA standard is voluntary self-imposed limits. Suppose we don't adopt that, but the first standard is made informed analysis, plan for trial, and second,
Yes.
an opportunity to be heard.
I think if the rule in this Commonwealth were the same as the ABA standard, I think Judge Saroof followed it. If the rule in this Commonwealth were the same rule that applies in the federal district courts in Massachusetts, that's local rule 43.1. Like what Judge Saroof was doing and what Judge Davis and Judge Brieger and all of the other judges, there have been 7 different Superior Court judges who have imposed similar time limits on these cases in the last 5 years. What they've effectively done is they are following the procedure that is laid out in Local Rule 43.1, which has been part of the practice of the federal district courts in Massachusetts for 30 years, which says in the absence of a voluntary agreement among the parties about the length of time the trial will take, the judicial officer will set the time, and that time will be meted out in hours so that the parties have the opportunity to decide how they're going to use their time. The presumptive split is 50-50, but for good cause, as shown by the parties, the court can vary any of that.
But the party with the burden of proof, both sides, but the party with the burden of proof has to present a case of narrative richness to meet a burden of proof.
I agree.
And they're saying that they couldn't call their addiction expert or put in depositions where there's statements of tobacco executives that are going to inure to the detriment of the defendant. So they're saying they couldn't put in the trial of narrative richness.
Right, and with all due respect to my friend on the other side, I challenge the premise. So Dr. Prochaska, the addiction expert, was, if you read her report, she was disclosed to testify about addiction, advertising, and product design. Dr. Cummings was disclosed to talk about addiction and company conduct. Dr. Proctor, company conduct, advertising, and product design. They were too deep at every position. And what they said, they never said to Judge Saruf, we're not calling Dr. Prochaska because of time limits. What they said to Judge Saruf, this is on page 305 to 306 of the third volume of the Record on Appeal. They said, Judge, there's a Daubert-Lanigan motion about this Dr. Prochaska. So long as you're going to deny the similar Daubert motions about the other two witnesses, we don't need Dr. Prochaska, so you don't have to hear argument about that witness. They told the judge that she was duplicative, she was cumulative. Here's the waiver point that we were attempting to make in our brief. Because I understand sometimes waiver is like, it's the refuge of last resort, like there's some magic word that you didn't say. That's not the point we're making here. The point we're making here is that if the task of this court is to evaluate whether Judge Saruf abused his discretion, the question you have to ask is, was he fully informed about what the plaintiffs now say is the consequence of his actions? The only conversations that took place about this topic happened at the pretrial hearing, where the plaintiff said, as a general matter, we can't possibly get this done in 28 trial hours. And the judge said, I think this is not supposed to be, I mean, I invite the court to read the whole, I'm characterizing, but please, it's a short transcript, read the whole thing yourselves. The judge says, I looked at what was done in Laramie, I'm giving you a lot more time. And again, contrary to what Mr. Rayner said, it is a lot more time that we were given. That was a 43-hour limit, this is a 56-hour limit. He said, I'm giving you more time precisely because there are two defendants in this case and not one. There are more claims in this case than in the other case, so I'm granting more.
And there was no causation issue in the other case?
Right.
That's a big deal, though, right?
I am not disputing that. I mean, as much as I think we both agree, tobacco cases are not cookie cutter. Every story is different, every plaintiff is different. But 80% of these cases is a roster of 5 or 6, some combination of 5 or 6 repeat expert witnesses who've testified dozens, sometimes hundreds of times. We know what they're going to say, the judges know what they're going to say, and which makes cases like this the perfect, these are the kinds of cases
Can I ask
where
on that
yeah,
point?
please.
So you said they were too deep in every position.
Yes.
So were those other cases, did they get to do too? Did they get to do too deep, or
So
only had to play their starters the whole time?
I will admit to Your Honor that I don't know the witness lineups off the top of my head in all of those cases. I will say, just as an officer of the court who has done something like 37 of these trials, it is it's not unheard of. It is very rare for Dr. Proctor, Dr. Cummings, and Dr. Prochaska all to testify in the same case. Have there been such cases? Yes. But the reason they don't usually all testify is that Cummings is also an addiction expert. I mean, Dr. Prochaska is an addiction expert.
How
but
about the sort of incriminating depositions? Because that, in Justice Lowy's words, that's the sort of rich narrative. Did they get to do a lot of the self-inflicted wounds?
I have 2 answers to that. The answer is, number 1, they played 3 different corporate representative videos at this trial, which, I mean, everybody's allowed to choose their own strategy. Taking Mr. Rayner at his word that they edited which videos they were going to play based on the fact that they had no time, which is something they never said to Judge Saruf, and they never asked for, can we have an extra afternoon for these videos, which are not long. But taking him at his word, they chose to play an hour's worth of video of corporate accountants reading slowly into the record the various metrics to, of the 2 defendants' financial condition, rather than accepting, we offered time and again a stipulation on net worth, which would have taken 2 minutes to read, but they wanted the net revenues and the income per day and all of these. So they that took, one of them was 34 minutes, the other one was 27 minutes. They played a 40-some-odd minute video of a Philip Morris corporate executive giving very, very intricate details about the company's consumer marketing database. Those are the choices that they made. So they didn't play Dr. Figler, and they didn't play 1 or 2 other, and they played 4 videos. They played a fellow named James Morgan, who was the CEO of Philip Morris 30 years ago talking about Marlboro Light cigarettes. Here's the danger. I'll bring it back to our what we called a waiver point, but it's more of a notice to the judge point. Yes, there were witnesses, there were videos that were listed in the joint pretrial memorandum that were not used at trial. That is not uncommon. Any of us who have been in a trial know that that is not uncommon, time limits or not. You a smart trial, a cautious trial lawyer.
Right, so
will-
I
yeah.
understand your point. I
Yeah.
mean, trial is all about making strategic decisions. And it does seem to me that you and your opposing counsel have what I call a tale of two trials, right? So, and we'll have to go to the transcript and figure out which is which. My question to you is, do we have a need? Is there a need to issue some guidance to trial judges on time limits?
Yes. I mean, I won't speculate as to why I'm standing here today and not in the intermediate court in Boston right now. But I suspect part of it might just be that we tried this case next door, and so it's thematic for the day. But I suspect that
I don't think that's
yeah,
why we're here.
perhaps, that's what I'm saying, perhaps we are here this morning because the only case law in this Commonwealth on this topic, and it is sparse case law, comes from the Court of Appeal. I think there are a lot of judges who are trying to, there's a judge shortage here in the Commonwealth. There are crowded dockets here in the, the tobacco cases alone are clogging up the dockets of every county in the state. And there are judges who are
Okay, so there's a need for guidance.
There's a
What
need,
would
yeah.
you suggest it be?
So I would suggest, so I don't mind the ABA standard that Mr. Rayner cited in his brief. I would also suggest that the court look at Rule 43.1 from the District of Massachusetts and look at, and again, this is another mea culpa and apology, I didn't discover this until 2 days ago. There's a report that was written in 1991. Your Honor's father was on the commission that studied ways to eliminate delay in the federal trial court that recommended, it goes into some detail. The reporter was Arthur Miller, and it goes into some detail about why trial time limits are good and how they should be implemented. And what the federal rule says is, first, the presumption is ask the parties to agree. If the parties can't agree, the judge, after consultation with the parties, which I suggest respectfully in this case is what happened. It was consultation both in writing and in 2 separate hearings. And in between the 2 hearings was when the joint pretrial motion was filed. So the judge had all of that before he made a final ruling. In consultation with the parties, set an amount of time. Set it in minutes, not by witness, but by trial, which the authorities say gives the parties the opportunity to make those kinds of strategic choices and use their time wisely. And then the sort of second half of that rule says, here's what you do if a party comes to you and asks to enlarge the allotment. And the rule presupposes that that ask is going to come mid-trial. And Judge Saroof, page 37 and page 42, he said I'd entertain it pre-trial. It never happened in this trial. And what the rule says is a judge can enlarge those time limits for good cause shown, taking into account, number one, whether the party who's making the ask has actually used his or her time efficiently so far, which is an inquiry that Judge Saroof was never given the opportunity to make because the ask was never made during trial.
Well, that's what, that dovetails into what my concern is, and this is a really big concern of mine.
That I'm happy that you're asking me.
So if we say these, whether it's 43.1, we say the ABA
Yep.
guidelines, it seems that may now be licensed to say, we're going to impose time limits everywhere, not just in particular kinds of cases. And I know you say that, you might say that it's not going to be 10 to midnight and the sky is going to fall. But the concern that I have is, you have situations where you mentioned with you and Attorney Rayner, you've had lots of these cases. Why do good lawyers need time restraints? I mean, you know these cases, you know the experts, you know the type of people that are going to testify. You just said, you know what they're going to say. So why should judges do this at all, except in an exceptional case? And I'm going to preface that with one other thing. If Attorney Rayner stands up here in response to Justice Wendland's question and said, I needed 3 more days, He's a good lawyer. He knows he needs 3 more days, and if there were none of these shot clock things, he would have put the 3 days. He knows how to try a case. You know how to try a case. You know when you're losing your witnesses. You know when you're losing your jury. That's part of what we do at trial.
I hear all of that, so I have a few answers. Number one, he could have had them if he asked. This trial took 8 full days and 5 half days. The only 2 times that the plaintiffs asked for a specific piece of extra time for a specific purpose, the judge said yes. They asked ex ante. They said, can the half day on October 29th be a full day because we want to make sure we finish Dr. Proctor? And the judge said yes. That added 2 hours of trial time. The next time they made such a request was on the very last day of trial when Mr. Rosenblum was told, you have an hour for closing argument. And he said, I really need an hour and 10. And the judge said yes. So if he really needed those 3 days to do something identifiable, he could have asked, and my suspicion is he would have gotten at least some of it. And it
Although
wouldn't have extended the
although,
deadline.
Again,
But I have a lot, yeah. I'm
there's
sorry.
some atmospherics that the judge is insistent, he's set a drop dead date.
Correct.
And he's keeping meticulous track of time. You've used 53 blank minutes, meaning he's not that susceptible to giving out additions, right? I mean, I haven't read the whole transcript.
And I
When we
invite you,
do,
I invite you to, if
are
we're,
we gonna find a lot of that where you've used up, you've used up
so
33
continuing,
minutes,
yeah,
you've got 2 seconds left.
continuing the theme of praising one another. It was very effective brief writing in the plaintiff's opening brief when they had that long block quote and they said it looks like it's like thousands of pages worth of transcript where they found the only instances of that happening. This was not a preoccupation of the trial. But here's my larger answer to your question, Your Honor. In addition to the fact that I think they could have gotten what they needed if they'd asked. There have been, to my knowledge, and this is approximate, and I think I'm getting it right, there have been 16 of these trials, these tobacco, personal injury, and wrongful death trials that have been tried in this Commonwealth in the last 5 years. 7 of them have had imposed time limits like this one. 9 of them have not. I don't know about hours, but just in terms of trial days, the average for the ones with time limits, they went 12 trial days, with varying mixes of full and half. The average for the ones with not, they went 14. It's not like these cases organically would be 3 months long, but the judge cut it down to 3 weeks. We're shaving a little bit. And every 2 days you save, that's a slip and fall case that can be tried that otherwise wouldn't have been tried in that session.
I don't know that necessarily helps you when you give me those numbers, because it would seem to militate in favor. Why do we need this?
Because in the aggregate, so here's my point. It's not like it has no effect. And I think the most telling part of the briefing in this case is where in the reply brief, the plaintiff says, we can't possibly articulate what the prejudice is because what's really going on is that we're nipping and tucking. We're editing here, we're editing there, we're not asking a question here, we're not asking a question there. And my contention is, if the only consequence to a time limit is that counsel is forced to edit, then that is per se a reasonable time limit that is not an abuse of
But
discretion.
don't you get a time limit when you have a pretrial conference, the final, and the judge gets an idea from the lawyers and tells the jury, we're gonna finish on such and such a date, and then during the trial, the judge sees the jury completely asleep and says, move on.
Right.
That
is fine.
happens all the time, correct?
It happens all the time. I want to make sure, and I don't think there's any confusion here. This side of the,
And to the peril of the lawyer who's making the jury go to sleep.
there's a lot of ways to skin the cat. This side of the V is not advocating for mandatory time limits. We are not saying that it is an abuse of discretion to use other means to move a trial along. I think there are a lot of ways to do it. There are benefits. I know I'm over talking about time limits, I'm over my time. But if I can just read briefly, we cited a case called Leroux from the Federal District Court. This is Judge Young, who has been a proponent of time limits for, as long as I've been aware of the existence of Judge Young, where he says the following. He says, time limits are an extraordinarily valuable focusing mechanism which promote cleaner trials directed to the matters genuinely in dispute, tend to eliminate those perennial redundancies which so frustrate and madden juries, and constitute perhaps the single most valuable technique available to a trial judge for scheduling a busy trial session. You can cut witnesses off, but if you have a set of cases like this where there's some predictability with a basic sense of what it's going to be, having a date certain, being able to tell jurors, being able to tell prospective jurors there's a date certain. So somebody who's got a vacation scheduled in week 5, we can say, no, you can serve, as opposed to maybe you can serve. So you don't have to summon double the jurors. We summoned like 150 jurors to get 8 people in this trial here during COVID, because everybody's got hardships. And some people hate tobacco companies and some people hate smokers. So it's hard to get a jury. If this were open-ended, if we didn't know if it was going to go 6 weeks long, we'd have had to call 300 jurors during COVID to try to get this done. Thank you.